You all are here this morning on the motion for enforcement filed by your client, Attorney Thompson. Is that correct?
Yes.
Okay, but I also see Attorney Glickman, you all have filed a special exceptions.
That's correct. And we also have a motion for enforcement that's going to be heard as well. I think we may end up passing our motion or our special exceptions and motion to strike today. We'd like to try to conclude this case and just let the sufficiency of the pleadings, you just defer to the court's judgment on the sufficiency for contempt. The case has been going on for a long time, and my client is struggling financially, and continuing litigation, I think, is just going to further exacerbate the problems these parents have.
Okay, which date was your motion for enforcement filed?
It was filed August 14th, 2023. And if you have, if you've received all of my exhibits, I have all of the live pleadings, and it's also marked in my index as the live pleadings that are before the court.
Okay.
It's Respondent's Exhibit 6.
And Attorney, now, you all been here before on a motion for enforcement that your client filed previously, Attorney Glickman?
That's correct. So mother's seeking enforcement of child support, and we're seeking to enforce this court's prior order for attorney fees that were awarded after father's motion to enforce visitation last year. I think that order was signed early January, shortly after both parties filed petitions to modify. I was recently put on this case, but it's my understanding that there was mediation conducted, and the parties did reach an agreement regarding their motions to modify. An MSA is on file. There's no order that's been drafted, but I believe Ms. Thompson is going to be drafting that pursuant to the MSA.
Okay, and Attorney Thompson, which date did your client file their enforcement?
Let me look. It's been almost a year. It's probably been over a year. Let me get the exact date.
The one I see is April 10th of 2023.
So that's about right.
Okay.
That's what I'm showing as well, but just so the court's aware.
She amended.
She did, and my client has not been served with that. And there's no order to appear on that motion. So there's an additional, I think, like 20-something claims or violations in there that were filed shortly before this hearing. And
the claims aren't new in there. The claims are just expanded. So they're not new, they're just a content. And if it helps us proceed today, we can withdraw the new claims, but everything is a continuation of what's there. There are no new claims.
I don't believe that's what the case law says. If there's additional claims, then that should be personally served. If you go by that is not an additional claim, personal service of a notice of hearing is required, and service on an attorney is not sufficient. So we also
there was an order.
Hold on. Guess what we're going to do? We're going to take up the special exceptions, and then we can set you all to have your motions heard at the same time, because I believe your special exceptions allows her an opportunity to amend again anyway.
That's correct, and I'd like to pass on my special exceptions and motion to strike, and so we can have a hearing today. My client's not going to be able to afford an attorney, and I'm going to end up probably having to withdraw, and she's seeking contempt on things that he's already been held in contempt for. He needs an attorney, and he's unable to comply with child support and afford an attorney. He's already spent like almost $20,000. He already spent like $15,000 last year on attorney fees, and mom has not reimbursed any of those attorney fees, and he is just dying, and it's killing him on all the attorney fees. And if we continue this, I'll probably end up having to withdraw and he's going to be without counsel.
Okay, here's the issue. We can't proceed with today if you're saying that he hasn't been served. So even if I reset this, he still, we would pretty much be at the same issue unless you're willing to accept service on his behalf. I'm sorry. Yeah, his behalf.
Well, I propose that we just go forward on Mom's original motion.
Okay. Counsel, is that what you would like to?
If we go forward on Mom's original motion, then the basis of the special exception was there were some deficiencies in Mom's original motion. So if we're going forward, then we'd be needing to go forward on the amended enforcement that was filed.
Mm-hmm. Which we couldn't go forward on if the argument is that he hasn't been served. So I don't know what you all want to do about that.
I mean, if we can remove, so I filed special exceptions, she filed an amended. Mm-hmm. If she waives her additional violations, then I'm happy to go forward because she amended, but not amended to cure, she amended to add additional claims.
Okay. Some of the curing was the claims because the medical support is in question and the amounts for the medical support were not in there. So a lot of the cures were breaking it down and adding additional claims. So that were some of the cures. I don't have a problem reserving and resetting. I don't have an issue with that, but I'm not going to waive my claims. So
I'm not asking her to waive her claims. There was 112 violations previously. Now there's like 132. She's saying part of what she's saying is that she had to add claims in order to cure, but she added additional claims. I'm saying that we can go forward on the way that her violations are written, 1 through 112, because she amended the language of those violations. And I'm happy to go forward on the amended language and the attaching of the order to be enforced. There's just additional claims. So, I mean, I'd like to proceed forward, but there are.
You're saying you want to proceed forward with the 112, not the 133.
We can go forward on her. I'm happy to go forward on her amended, as long as she waives the 113 through 133.
So that's what I just said. So you're wanting to go forward on the 112.
Yeah, within her first amended.
Okay. And counsel, you're saying no. Honestly, it really doesn't make a difference. It just doesn't. Like whether you choose to go the 112 or the 133, she still has the burden to prove it.
Right. Okay. Well, I mean, I'd like to get this resolved today. In the interest of judicial economy and trying to resolve this matter, Your Honor, I hope you recognize I'm trying to push this case and conclude it today. And
yes. Okay, so we're going to go ahead and begin. Both sides ready to proceed?
Yeah.
We're on the record and cause number DF 1420778. Counsel, will you please announce for the record?
Jasmine Thompson for moving Tamisha Jackson.
Dawson Glickman, attorney for Tyrone Turner, respondent and counter petitioner for other movement in his motion for enforcement. The state bar number is 241-21640.
All right.
Your Honor, I have a question. So are we going forward on both enforcements today? Because I thought we said that only one was set. So are we going forward on both enforcement?
Which one is set? Whichever one is set today. But I think it would, for the interest of justice and what Attorney Glickman is requesting. Wait a minute. Before I say that, has your client been served with their enforcement?
Yes, she's been served, but the reason I was asking is because the court allotted an hour for us today, and that's all that I allotted was an hour for our enforcement.
Your Honor, I confirmed with the court, and they said that both of these motions were supposed to be set for hearing today. If you look at the pretrial order, everything was set for today.
It is set for today. Counsel, I'm just wondering where you got this hour from.
That was when we were here, we said that it was going to be 30 minutes each side. And then on the court notes, it says 30 minutes per side.
Oh, okay. Per side. Yes.
Yes.
Okay. I was like, I don't know where you got that hour from per side. Okay. Yes. So I'm setting you all's timer.
And just for a little clarity, it's 30 minutes per side per motion or for the whole hearing?
For the whole hearing.
Okay.
You really have, if you think about it, you have 15 minutes to present your own motions. And then the additional 15 minutes were for you to defend the motions. And the state, they have time as well, but they normally don't use up 30 minutes. And Attorney Dale, did you announce?
Not yet, Judge. Justin Dale for the Office of the Attorney General, who filed the intervention into the action.
Thank you. With those who intend to testify, please raise your right hands.
Tyrone, can you please?
Oh, and you have to turn your camera on. There you go. All right. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Mr. Turner, you're on mute.
Yes.
Okay, thank you. Give me one moment. Someone just walked into the courtroom. I'll be right back. Okay, so your time will include any opening statement, any opening, closing statement should you choose to make one, and it will also include your examination. Attorney Glickman, I do have exhibits from you, and Attorney Dale, I have your exhibits as well as yours, Attorney Thompson. All right. Is there any objection to either side's summary of requested relief?
Number me.
I have not. Let's see. I mean, I have objections just to her requested relief in that he's already been held in contempt for some of the violations she's requesting, but no objections as a summary.
Okay, so Attorney Thompson, is this exhibit 1?
No, I just titled the summary of requested relief. The exhibits are numbered in the initial email. So the requested relief, I think, would end up being number 6. No, 7, because I said 6. So it'd be 7.
Okay. So father's exhibit 7 is admitted. And
maybe mother's.
I'm sorry, mother's exhibit 7 is admitted and father's exhibit 1 is admitted.
And Your Honor, I would like to offer just Respondent's Exhibit 3. It's order of commitment and suspension of commitment, and also a summary of our requested relief. It's just our proposed order.
Okay, so a proposed order, I'm not admitting that as as evidence. It'll be an aid for the court.
Okay.
Okay. All right. Attorney Thompson, did you want to make an opening statement?
I know, Your Honor.
Go ahead.
Your Honor, just real quick. We both emailed our requested relief this morning. That's not in the initial email, so I was just making sure that you did receive that.
Did you get another email?
Everything I got from them, I
See, I just wanted to make sure you actually had the requested relief.
Yeah.
Okay.
Okay, go ahead, Attorney Thompson.
I'd like to make an opening statement as well.
Okay, you'll go after she goes.
Okay.
Go, Attorney Thompson.
Okay, I called Tanisha Jackson to the stand.
Oh, did you? You didn't want to make an opening statement?
Oh, yes, Your Honor. I apologize. I'll skip that. I'm sorry.
Go ahead.
Okay, Your Honor, we're here today asking the court to hold Mr. Turner in contempt and to, at this point, impose the maximum penalty that the court can impose. Mr. Turner has, as you've heard already, been held in contempt for not paying child support, and he's continued to not pay. Today, we will show that Mr. Turner has not paid child support in almost a period of 10 years, in addition to not holding the child on his, not carrying the child on his medical insurance, which has caused my client additional funds that she's had to pay for. So for those reasons, with the evidence that's presented, we're going to ask that you do hold Mr. Turner in contempt of court. Mr. Turner is going to try and convince the court that he does not have the resources.
Hold on one second, Attorney Thompson. Mr. Turner, you have to keep your camera on the entire time. Okay, go ahead.
Okay, Mr. Turner is going to try and convince the court that he does not have the resources to pay child support, that he's not able to pay child support. However, I'd just like to remind the court that, number one, that's not before the court today. Number two, in the modification that was just filed, Mr. Turner did not mention anything about his child support obligation and changing his child support obligation because of resources. So at this point, we would ask the court to overlook that as it's not what's there today and hold him in contempt.
Thank you. Attorney Glickman?
Yes. In 2023, the father sought to enforce his visitation rights, and this court found that based on Ms. Jackson's testimony and the evidence presented, Ms. Jackson had repeatedly violated the order on several occasions. This court rightfully awarded $7,400 in attorney fees and interest that were enforceable as a child support obligation. However, despite this court's order, Ms. Jackson has failed to comply with her financial obligation, or still her actions betray a misguided belief that she can disobey the court's orders with impunity under the mistaken assumption that this honorable court won't enforce her obligations. This defiance not only undermines the authority of this court, but continues a harmful cycle of noncompliance. Furthermore, had Ms. Jackson fulfilled her obligations to reimburse the father for attorney fees, he would have been better able to fulfill his support obligations. Instead, her insistence on holding the father in contempt for non-payment of child support and seeking his incarceration is not only punitive, but also detrimental to the child's best interests. It's worth noting Ms. Jackson's alleged violations 1 through 19 were the basis of a prior order for enforcement signed January 10th, 2018, and Mrs. Jackson is requesting that Mr. Turner be held in contempt for the same violations a second time. Additionally, Ms. Jackson is requesting Mr. Turner be held in contempt 49 times for a single contemptuous act of failing to maintain health insurance, and an additional on or about 20 more violations in her first amended in violation of the Texas Supreme Court holdings. And I have that case law. We not dispute the father has arrears or his responsibility to provide support. Mr. Turner is a devoted father and deeply involved in his child's life. However, he faces significant financial challenges due to his disability, relying on merely $1,800 a month in veterans' disability benefits and part-time work from his photography business. Despite his limitations, he has strived to meet his obligations, making periodic lump sum payments to the mother as available. Conversely, Ms. Jackson enjoys the luxury of a dual-income household with an approximate gross income of $180,000 in 2022, rendering her financially independent from father's support. And it's evident that the father's financial resources pale in comparison to Ms. Jackson's. Nonetheless, he seeks a support order that aligns with his means, ensuring fairness and equity. Currently, the father's efforts to address his arrears amount to a nominal $100 a month, while the interest accrues at an alarming rate of nearly $200 per month, further exacerbating his financial burden. Currently, the father has outstanding attorney fees of over $10,000 for this suit and approximately $6,000 from his previous suit for enforcement of visitation. Your Honor, in light of the circumstances, we urge the court to confirm his arrears, confirm mother's arrears, and order a reasonable payment schedule in accordance with their means, because further litigation will only exacerbate their issues. That's all, Your Honor.
Thank you. Attorney Dale, would you like to make an opening statement?
No, thank you, Judge.
Okay. Attorney Dale, I understand you all have a lot of cases. So I'm
Well,
trying to, go
I'm
ahead.
free right now. I mean, I have time right now, Judge.
Okay.
My portion will only take a couple of minutes, but I'm free to proceed to remain.
All right. Thank you. Attorney Thompson, you may call your client.
Okay, I call Tanisha Jackson. Ms. Jackson, can you state your name for the record?
Tamisha Jackson.
Okay, and you brought this enforcement bill for the court today?
Yes.
Okay, and what are you asking the court to do?
Just have Tyrone realize that he has to pay child support.
Okay, and when's the last time he paid anything on the child support, if you remember?
I think last year. I'm not sure. I can pull it.
Okay. Hang on, I'm gonna show it to you. Give me just a second. Okay, Your Honor, can I share my screen?
Yes.
Okay, can you see my screen, Ms. Jackson?
Yes.
Okay, and do you recognize this document?
Yes.
Okay, and what can you identify to the court what this is?
I believe that's the payments that Tyrone has made.
Okay, Your Honor, move to Exhibit 3.
Okay. Any objection?
Well, I haven't seen anything on the screen.
It's there.
Is it? Oh, sorry. Can you scroll down just a little?
Yeah, these are the same exhibits that I emailed to the court last week.
No objection, Your Honor.
Okay. Moving to Exhibit 3 is admitted.
Okay, Ms. Jackson, on the very last line, could you read the date for me?
July 1st. That one, July 1st, 2002.
Okay. Yes, and I would like for you to go up to the line that says 629.23.
Yes.
And does this reflect an $800 payment?
Yes.
Okay, and outside of that $800 payment, has Mr. Turner made any payments to you since then?
No.
Okay, and does this show that as of now, the total amount that he was behind when we took this snapshot was $47,905?
Yes.
Okay. And I'm going to show you what is being marked as Exhibit 1, if I can share my screen again. Okay, are you able to see my screen?
No, it's some icons.
No. Okay, let me try again. I'm sorry about that, Your Honor. I'm trying to figure it out. Okay, Ms. Jackson, while I'm trying to get that loaded, who was ordered to carry your son on health insurance?
Tyrone.
And to date, has he ever carried your son on the health insurance?
I think like at the beginning when Aiden was born, but not since.
Okay, and who carries your son on the health insurance?
My husband.
Okay. Okay, and can everybody see my screen?
Yes.
Okay. Do you recognize this document?
Yes.
Okay, and without going into the contents of the document, could you tell the court what it is?
A child support order for
Okay.
Tyrone.
Your Honor, we move to admit movement exhibit 1.
Any objection?
Movements Exhibit 1 is just the original order. Is that right?
Yeah. Yes.
No objection. I would object that she failed to provide any reference to that provision that he's required to provide health insurance in her motion.
Okay,
Testifying to issues that are not properly pled.
objection overruled. Movements Exhibit 1 is admitted.
Okay, and Ms. Jackson, in this order, do you remember how much Mr. Turner was ordered to pay in child support per month?
I think it was like $640 a month.
Sorry, I'm looking for it. Okay, was it $645 a month?
Yes.
Okay. And at the time that this order was signed, was Mr. Turner already in arrears for child support?
I actually don't remember.
Okay. But has Mr. Turner been held in contempt for not paying child support before?
Yes. Yes.
Okay. And did he ever pay the child support?
He paid because a judge ordered him to pay a certain amount before he came. And then that was it. He did that. And then after the case, he didn't pay anything else.
Okay. And then can you see my screen?
Yes.
Okay. And could you tell the court what this is?
It looks like payments. Yeah.
Okay. And Your Honor, we move to admit movements Exhibit 2.
Any objection?
I apologize. What exhibit is that? Okay.
2.
Can you scroll back up? Optional completeness, Your Honor. This is going back behind the prior order, and she's saying that no payments were made after the prior order, and there's been over 18,000 paid after the prior order. That's a misrepresentation of the payments that she's received. I object, Your Honor.
If combined with the other exhibits, Your Honor, I believe it gives the court a complete picture.
Your Honor, I have marked as an exhibit a full complete payment record history and payment record history from the date of the prior order. This misrepresents his payments, and I think it's confusing.
In terms of the document itself, what is the date of the original order?
There was a contempt order that all of these payments, they were prior to.
Oh, what was the date of the prior order?
It was January 10th, 2018.
Okay, so and that's the original order, because I see payments on here from 2014.
The original order was 2014.
Okay, so objection is overruled. Which exhibit number is this?
Number 2.
Number 2 is admitted. You may proceed.
Okay. And Ms. Jackson, I'm going to show you another document. And sorry, I'm trying to move fast so that we don't run out of time. Please let me know if you recognize this document when you're able to see it. Okay, are you able to see my screen?
Yes.
Right. Okay, and can you tell the court what this document is briefly?
That's for my husband because he has aided on his insurance.
Do me a favor, counsel. Stop sharing that document.
Oh, okay.
It has their address on it.
Oh, okay. We're on YouTube. I apologize, Your Honor. Thank you.
Go ahead.
Okay. And is that a fair and accurate copy of the benefit statement?
Yes.
Okay, Your Honor, we move to admit movements number 5.
Objection?
Objection, Your Honor. No foundation properly laid. This is an exhibit. This is produced from her husband. It's from her husband's employment. He's not here to testify to this. This is not her records. It's her husband's records. And she doesn't have personal knowledge of his employment.
Your Honor,
Go ahead.
Your Honor, she does have personal knowledge. She pulled the document. She's carried on the health insurance, and her husband are married. It's a shared expense.
Okay, so do you want to ask her some more questions for foundation?
Oh, yes, I kind of asked them earlier, but I'll backtrack and said I was trying to get the screen shared. So I'll ask her a few more questions.
Go ahead.
Ms. Jackson, who was ordered to carry your son on health insurance?
Tyrone.
And when's the last time, if you remember, that Mr. Turner carried your son on health insurance?
It was like when he was 2 years old, like maybe 8 years ago.
Okay, and since then, how is your son covered by health insurance?
My husband.
Okay, and about how long has your husband carried him?
Since we've been married, so like 4 years.
Okay, and are you familiar with the premiums? Are you familiar with the coverages?
Honestly, no. I let him handle that. That's not my cup of tea, but I do know he's covering him.
Okay, and are you aware of how much he pays roughly?
No, I can look it up, but not off the top of my head.
Okay, but you do know that so if I showed you a benefit statement, would that be the first time that you saw it?
No.
Okay. Your Honor, we move to admit Exhibit 6 again. Objection. And I didn't, sorry, Exhibit 6 is another one.
Objection, Your Honor. No proper
Exhibit 4.
Foundation has been laid. She has not proved up this exhibit.
Your Honor,
the objection to hearsay is sustained.
Okay. I'll pass the witness at this time, Your Honor.
Okay, Attorney Glickman.
Good morning, Ms. Jackson. My name is Dawson Glickman. I'm representing Tyrone Turner in this matter. Could you please state your name for the court?
Misha Jackson.
And if the court finds Mr. Turner in contempt today, are you requesting that he be incarcerated?
I am requesting that he has a punishment for his actions.
Objection, non-responsive.
Sustained.
Are you requesting that he be incarcerated today?
Yes.
And do you agree that if the court finds you in contempt today for violating this court's prior order, that you should be incarcerated as well?
I don't believe I should be.
Is it your best parental judgment that the father should be incarcerated for failing to pay child support, despite his continuous efforts?
Objection, compound question.
He didn't finish it. I didn't hear it. Continue. Go re-ask the question.
Is it your best parental judgment that the father should be incarcerated for failing to pay child support, notwithstanding his continuous efforts to pay support and be involved in Aiden's life?
Objection, compound question.
Overrule.
Can you explain the question you're asking?
Is it your best parental judgment that the father should be incarcerated for failing to pay child support despite his efforts to pay and his involvement in Aiden's life?
I don't think he's made an effort to pay.
Objection, Your Honor, non-responsive. It's yes or no question.
Sustained.
Yes.
Isn't it true that you have a dual income household and you don't really rely on Mr. Turner's?
Objection, relevant.
It's relevant.
Relevant. So, okay, so here's the question was, Isn't it true? That's all I got on his question, his second question.
Isn't it true that you have a dual income household?
I'm going to object to relevance. Mother's household income has nothing to do with father's obligation to pay child support, nor is that what's before the court today.
Sustain.
Your Honor, under Texas Family Code 154.123, the court's able to determine.
Sustain. Ask your next question.
Thank you, Your Honor. Isn't it true that you don't really rely on his income for support?
Objection, relevance. Again, that's not what we're here for today.
Your Honor, it goes to
sustain. Ask the next question.
Isn't it true that you were ordered to reimburse Tyrone Turner $7,400 approximately plus interest to reimburse him for attorney fees that he incurred to enforce his visitation rights?
From my understanding, and I thought that I was supposed to pay the attorney and not Tyrone.
Now, did you pay that attorney?
No.
Have you made any payments to that attorney?
No.
Have you made a dollar payment to that attorney?
No.
Do you think that Mr. Turner would have more funds available to you to provide support if he didn't have to file a motion to enforce his visitation in 2022?
Objection, improper line of questioning. We've already dealt with it. And again, that's not what's before the court today.
It goes to his ability to pay.
Hold on. Do you think Mr. Turner would have more funds available to you to provide support if he didn't have to file a motion to enforce his visitation in 2022? The objection is overruled. Ma'am, you may answer that question.
I think that he could have paid child support instead of the court. Us being in court.
So you do think he would have more funds available if he did not have to enforce his visitation in 2022?
Absolutely.
Objection, improper line of questioning. We're not here about.
He already answered. It was asked and answered. Attorney, go ahead.
It was just a clarification. And do you think he'd have more funds available to provide you with support if you had reimbursed him for those attorney fees?
Objection, asked and answered. We're asking the same question over and over again, just using different words.
That's incorrect.
No, that's a different question. You may answer the question. The question was, do you think he'd have more funds available to provide you with support if you had reimbursed him for those attorney's fees?
I was supposed to reimburse the attorney, not him.
You may ask your next question, Attorney Glickman.
Do you think that he'd have more funds available if he didn't have to seek enforcement of this court's order of attorney fees?
Objection, asked and answered.
Overruled. That's a different question.
Can he repeat the question?
Do you think Mr. Turner would have more funds available to him to provide support if he didn't have to seek enforcement of this court's order for attorney fees?
Yes.
Do you think that he'd have more funds available to provide support if he didn't have to defend against your motion for enforcement of child support?
Yes.
Let me show you your motion for enforcement. And I understand that we're going to be based off of the first amended, but I have some notes made in her original, so we can just use that as a reference, if that's all right. Is there any objection?
It's your time.
Permission to publish, Your Honor.
Go ahead.
So it's Ms. Jackson, can you see what's marked as Respondent Exhibit 7?
Yes.
Do you see these violations, specifically what's been highlighted, violation 1, November 1st, 2014?
Yes.
And just scrolling down, you see these dates, October 1st, 2016, violation 8. And going through violation 19, October 1st, 2017. You see that?
Yes.
So violations number 1 through violation 19 occurred between, let's see, November 1st, 2014 and October 1st, 2017. You see that?
Yes.
Isn't it true that you were a party to an order of enforcement of child support that was entered on January 10th, 2018?
Yes.
Your Honor, I'd like to offer Respondent's Exhibit 12 as an aid to the court, which is an order of enforcement that was entered on January 10th, 2018.
Any objection?
Well, 12, so not this one. No, no objection to 12, Your Honor.
Okay. Respondent's Exhibit 12 is admitted.
And this is, so now we're looking at Respondent's Exhibit 12. I'd ask the court to take judicial notice of the order enforcing support obligation that was entered on January 10th, 2018.
The court takes judicial notice of the order entered January 10th, 2018, as well as all of the court's file.
And specifically, Your Honor, I'd like you to take judicial notice of page 2, where it states that it was found and confirmed he's in arrears in this amount as of December 31st, 2017. And
the court took judicial notice of the entire document.
Thank you, Your Honor. And he was ordered to make monthly payments of $100 towards any arrearages that occurred on or before December 31st, 2017, and take judicial notice that mother's alleged violations 1 through 19 on page 2 and 3 of her motion for enforcement occurred before December 31st, 2017.
Counsel, are you asking her questions on cross-examination?
I am. I'd just like the court to take judicial notice that violations 1 through 19 occurred prior to this order.
Okay, the court already took judicial notice of all contents of the court's file. Let me try to help y'all streamline this, because neither one of you are really giving me what I need for an enforcement. You both kind of going all over the place. And enforcement is very specific. You prove up each violation of the motion, the allegations that are in the motion, and on defense, you just try to strike them down. You all are going all around the world and wasting time, and I want you to get to the crux of what it is that you want me to do.
Thank you, Your Honor.
You're welcome. Go ahead.
Ms. Jackson, in violation 20, you state, on March 1st, 2018, Tyrone Turner failed to remit the court-ordered child support payment in the amount of $645. Isn't that true?
Yes.
Isn't it true that that statement inaccurately reflects the actual payments that you received?
I don't have that document in front of me.
So isn't it true that he was ordered to pay you $645 a month?
Yes.
Isn't it true that he actually paid you $1,935 for child support between January and March 2018?
Objection. Counsel is mischaracterizing the evidence. The child support that was paid on that day was for child support that was due like 2 years before it was paid.
Okay, you can clean that up on redirect. Overrule. Go ahead, Attorney Glickman.
Isn't it true that Tyrone Turner actually paid you $2,100 from January 11th, 2018 through March 1st, 2018?
I would need to pull up the document to answer that.
Let me show you what's marked as Respondent Exhibit 22. This is the OAG payment record from the date of the prior order of enforcement to March 5th, 2024. See if this refreshes your memory. So let's see. You're saying that he failed to pay you $645 on March 1st, 2018, and yet he paid you $700 on April 2nd, 2018, and then $1,400 on May 25th, 2018. Is that correct?
Your Honor, I'm going to again object to mischaracterizing the evidence.
Overrule.
Ms. Jackson, violation 21, you state on July 1st, 2018, Tyrone Turner failed to remit the court-ordered child support payment in the amount of $645 on July 1st, 2018. Is that correct?
Yes.
Isn't it correct that on August 23rd, 2018, he paid you $1,400? And on May 29th, 2018, he paid you another $1,400?
Yes.
Isn't it true that from May 29th, 2018 through August 23rd, he actually paid you $2,800?
I believe that's when we was in court and he was ordered to pay those amounts.
Isn't it true that he was only ordered to pay you $2,580 from May through August?
I'm not sure. I know we went to court and she kept telling him he needed to bring a certain
Objection, non-responsive.
Sustain. After, I'm not sure.
Isn't it true that you're asking the court to hold Mr. Turner in contempt, notwithstanding actually receiving more money than the child support obligation during this period?
It's not more money because he didn't pay before.
Through this period. So you're asking that he be held in contempt for a period which he actually paid you more.
Objection asked and answered. The witness should answer the question.
In regards to violation number 60, you say on March 1st, 2022, Tyrone Turner failed to remit the court-ordered child support payment in the amount of $645. Is that correct?
Yes.
So on March 1st, you state that he failed to make that $645 payment. Isn't it true that Mr. Turner made a $500 payment in February and a $5,500 payment the following month?
In what year are you talking about?
In 2022, in violation 60, you say on March 1st, 2022, he failed to pay you $645. Isn't it true that he made a $500 payment to you on February 24th, 2022, a $5,000 payment to you on April 21st, 2022, and another $500 payment to you on April 25th, 2022? But the month right in the middle, on March 1st, 2022, you want to hold him in contempt, even though you received $6,000 over those 2 months.
Yes, he didn't pay before previously.
Non-responsive after yes.
Sustain.
Isn't it true that you're asking this court to hold Mr. Turner in contempt, notwithstanding actually receiving more money than his child support obligation during this period?
I didn't ask. That was the Attorney General who pulled that amount. To my understanding, he didn't.
Objection.
He didn't pay that on his own.
Objection after, I don't know, is the Attorney General.
Sustain. To non-responsive.
In regards to violations 63 through, I believe it's 133 in your first amended, you state on 63, on January 1st, 2019, Tyrone Turner failed to carry health insurance on the child. Violation 64. On February 1st, 2019, Tyrone Turner failed to carry health insurance on the child.
Excuse me, Your Honor, what are you looking at? Because that's not matching up with 63 on the first amended.
I apologize. Right here. Yeah, I apologize, Your Honor. I was reviewing, or I was looking at the original. Okay, on violation 72, you state January 1st, 2019, he failed to carry health insurance on the child. Tamisha Jackson and her spouse has carried health insurance on the child at a cost of $140 per month. Is that correct?
Yes.
Can you please identify in your motion the provision and the portion of the order allegedly violated that you seek to enforce?
Can you restate?
Can you
I'm gonna
identify?
object.
Can you identify in your motion the provision or portion of the order allegedly violated that you seek to enforce? Where does it say?
Your Honor, I'm gonna object.
Hold on, you all cannot talk over each other. What's the objection?
He's asking the witness to make a legal conclusion, and she's not gonna know where to find it in the motion.
Sustain.
Are you aware whether or not your motion contains a provision or tells Mr. Turner that he's supposed to have health insurance on the child?
When we went to the first thing to get child support, he was told that.
In your motion that you're seeking to put him in contempt, did you tell him which part of the order he was supposed to comply with?
Objection asked and answered, and objection again. He's asking.
Sustain as to ask and answer. You may ask your next question.
Thank you, Your Honor. In regards to violations 1 through 71, can you please tell me how he failed to remit the payment?
I'm sorry, how did he?
You say that in violations 1 through 72 or 71, you say that Tyrone Turner failed to remit the court-ordered child support payment. Can you tell me how he failed to remit the child support payment?
He didn't send it. I don't.
Well, did he fail to remit the payment to the OAG or you?
To the attorney, to the OAG.
Did he actually pay you, but not through a method ordered by the court?
He did not pay me anything.
Your Honor, I just request the court to take judicial notice on page 8 of the order enforcing support obligation that was signed January 10th, 2018. He was held in contempt and ordered committed to county jail for 180 days for the same contemptuous acts Ms. Jackson currently alleges in violations 3, 9, 10, and 13.
The court has already taken judicial notice of the entire document.
Okay.
Time check, you, Attorney Glickman, you have 4 minutes. Attorney Thompson, you have 18 minutes and 48 seconds. Attorney Glickman, you may ask your next question.
Are you asking that Tyrone Turner be held in contempt for the same acts that he was previously held in contempt for?
Yes.
Were you a party to an order on motion for contempt regarding enforcement of visitation that was entered on January 18th, 2023?
You're asking me, was I in court on January 18th?
Yes. Were you a party to an order?
Yes.
I'd like to offer Respondent's Exhibit 11, order on father's motion for contempt that was signed January 18th, 2023.
Any objection?
No, Your Honor.
Okay, Respondents Exhibit 8, Respondents Exhibit 11 is admitted.
Have there been any modifications to this order?
To the court, no, the child support order, no.
No,
Which order are you talking about?
the order on father's motion for contempt that was signed January 18th, 2023.
No, I don't believe so.
Isn't it true that you failed to file an answer to Tyrone Turner's motion for enforcement?
Objection. Objection again. It calls for the witness to make a legal conclusion.
Your Honor, I'd like the court to.
Furthermore, we're already.
Hold on. That question is not relevant. We're already here today.
That's correct. Isn't it true that you failed to disclose any legal theory in support of your claim or defense regarding Mr. Turner's motion for enforcement?
Objection. Asking the witness to come to a legal conclusion. She would know that. Furthermore, all the deficiencies with the initial disclosures have been cured prior to today.
Sustain.
Pass this witness, Your Honor.
Okay, Attorney Thompson.
Yes, Your Honor. Ms. Jackson, so you testified that before Mr. Turner was held in contempt in order to go to jail, correct?
Yes.
To your knowledge, did he ever go to jail?
No.
And to your knowledge, did he ever pay the $14,000 in arrears that were ordered from the 2018 order?
No.
And in your enforcement allegations 1 through 71, you are you're asking the court, you're telling the court that Mr. Turner failed to pay the ordered amount of $645 each month, correct?
Yes.
And in those allegations, there are some months that you left off, is that correct?
Yes.
And the months that you left off, is it because there were some months that you did receive payments?
Correct.
As far as the March 2018 payment, did you include that in your enforcement? Because at that point, every payment that Mr. Turner made went to arrears.
Yes.
And has there ever been a time where Mr. Turner was caught up on?
Objection, Your Honor. Leading counsel's testifying. She doesn't know whether or not that goes towards arrears.
Hold on. If you all could just make the objection, I don't need the extra commentary.
Okay. Objection, Your Honor.
Objection. What's your objection?
Counsel's testifying leading.
Sustained to leading.
Okay, and Ms. Jackson, since the inception of this order, has there ever been a time where Mr. Turner was not behind in child support?
No.
Since the inception of the order, has
Leading,
Mr.
Your
Turner?
Honor.
Overrule.
Since the inception of the order, has Mr. Turner ever made a child support payment on time?
No.
And you were asked about Mr. Turner's efforts to pay. Would you, in your opinion, has he made any reasonable efforts to pay child support?
No.
Okay.
Yeah.
And you were asked about Mr. Turner's ability to pay child support and as it related to him having to pay attorney's fees. Do you remember that?
Yes.
Was Mr. Turner paying child support before this most recent litigation started?
No.
Okay, so would it be safe to say that him filing a motion to enforcement had no bearing on his child support?
Correct.
Okay. And for enforcement actions 72 through 133, are those based on Mr. Turner failing to carry health insurance on your son?
Yes.
And does your husband currently carry health insurance on your son?
Yes.
And is your son's portion approximately $140 a month?
Yes.
Okay, and because of Mr. Turner's failure to pay child support, what are you asking the court to do?
And make him pay.
And at this point, do you feel that Mr. Turner is going to pay?
No.
How many enforcement actions have been brought based on child support before today?
I know we went to court around 2018 and he was supposed to pay and he didn't pay those times.
Okay, and has Mr. Turner has he ever had to face any consequences for his failure to pay child support?
No.
Okay, I pass the witness, Your Honor.
Okay, anything further for this witness?
No, Your Honor.
Okay, Attorney Dale.
Thank you, Judge. Miss Jackson.
Yes.
I'm sorry, could you please stop sharing the screen?
Me?
Oh, I apologize.
Oh,
No, I think it. Oh, okay, thank you. Miss Jackson, can you hear me?
yes.
Okay. In the past 6 months, has Mr. Turner made any child support payments directly to you?
No.
Has he made any direct payments to you within the past year?
Not to my knowledge. No,
Okay.
he hasn't given me any money.
Has he made any direct payments to you within the past 2 years?
No.
Are you wanting to release any of the money that he owes you today?
Does that mean have him not pay it? What
Are
does
you
that mean?
wanting any of the money that he owes you? Are you wanting it to go away? Are you wanting to release any of it?
No.
Okay. Your Honor, I offer into evidence what's marked for identification purposes as State's Exhibit a copy of the payment record, Judge, which is current and goes through this past Friday.
Okay, any objection?
No objection.
No objection.
All right, State's Exhibit A is admitted. Attorney Dale, just so I'm reading this right, the amount due for child support, is it that $54,677.93?
Correct.
Okay, thank you.
I pass the witness.
Thank you. Let me see, is there going to be anything additional from the state? Because the next motion is attorney's fees.
Nothing additional, Judge. I can provide a very brief closing on my portion if you'd like.
Go ahead.
Thank you, Judge. The state's asking that a child support judgment be granted against Mr. Jackson in the amount of $54,677.93 as of today's date, March 18th, 2024. And Your Honor, given the interest in the case, the state would request that a payback be ordered in the amount of $323 starting April 1st, 2024.
Okay. All right. Thank you. Is there any objection to the state being released?
Not for me, Your Honor.
No objection.
Thank you, Attorney Dale. Attorney Dale, are you also here on the 10:30?
No, Judge.
Okay.
Not today. I have something with you tomorrow morning at 11.
Okay. Thank you.
Thank you, Judge.
Have a good day. Attorney Thompson?
Yes. Okay, I call Tyrone Turner to the stand.
Okay. Mr. Turner, I have to make sure I give you this admonishment here. Today's suit is related to the failure to pay child support, which is quasi-criminal, which means that there is an element of contempt where you can face jail time. You do have the right to invoke your Fifth Amendment right should you choose to do so and not testify. And I'll allow you to ask your attorney about whether or not you choose to testify here today.
Well, can I ask them privately or do I need to ask them on here?
You can ask them privately. Hold on one second. I'm going to put you in a breakout room. I have another case that's going too. So I'm going to.
Yeah, and I can withdraw calling this attorney to the stand in the interest of course time. I don't have to call Mr. Turner.
Well, he needs to ask anyway because his attorney tries to call him.
We did talk about this yesterday.
Okay.
And we did discuss his ability to testify, whether or not he should testify. I do think it is in the best interest that the court does hear him testify and gets his, gets to hear his side of the story. So, if he'd like to talk with me more, I'm happy to do so, but I think that we're on the same page, and I would like him to testify if she's going to call him or would like to.
Okay. Mr. Turner, did you want to speak to your attorney?
Fine, let's move forward.
Okay. All right, Attorney Thompson.
Okay. Mr. Turner, could you state your name?
Tyrone Turner.
Okay. And your attorney brought up that you've spent a considerable amount of attorney's fees through the course of this current litigation. Is that correct?
Yes.
Okay. And do you think that it would have been a wiser use of that money to just put it towards your child support arrears?
I reached out to try to negotiate what we come to court for, and there was no negotiation. So I was forced to go to court.
Okay, but so I'm going to re-ask the question. Do you think that the money that you've spent in attorney's fees would have been better suited going to pay your child support arrears?
No.
Okay. And are you aware that it's being alleged that you're behind over $50,000 in child support?
Yes.
Okay. And do you feel that you've made a good faith effort to pay your child support?
Based off my financial situation, yes.
Okay. And you understand that we're not here today to discuss your financial situation, correct?
Correct.
And did you file a modification last year?
I believe I filed a motion to enforce.
Okay. And did you ever ask the court to change your child support obligation?
No, we were tied up with this.
Okay. I'll pass the witness, Your Honor.
Okay.
Turner, if I were to ask you everything you're asking this judge to do today, would Response Exhibit 1 be a summary of your testimony?
Yes.
And did you contract for my legal services at $250 per hour?
Yes.
And was it necessary to secure the services of myself, a licensed attorney, to enforce and protect the rights of you and the child, the subject of this suit? And was it necessary to ensure the children's physical or emotional health or welfare?
Yes.
What are you asking the court to do about who pays legal fees?
I'm asking that they ask her to pay it, or yeah.
No further questions, Your Honor. I'd just like to call myself to put on
Okay.
please.
Go ahead.
My name is Dawson Glickman, an attorney licensed to practice law in the state of Texas. I've been licensed since 2020. I'm familiar with the customary rates and reasonable fees in Dallas County for an attorney of my experience. I charge $250 an hour, which is reasonable given my experience. And Tyrone Turner's previous counsel, Brandon Burlin, Tyrone's prior counsel, charged an hourly rate of $284 per hour, which I believe is reasonable considering his experience. Brandon Burlin and I were contracted by Tyrone Turner at those rates. I'd like to offer Respondent Exhibit 28, which is a summary of attorney fees.
Any objection?
Your Honor, it sounds like there are multiple attorney's fees being added in here.
No.
Okay. You can ask him that on cross-examination. Is there any objection to the document?
No objection to the document.
Okay, and I didn't catch that exhibit number, counsel. Which exhibit number?
It's Respondent Exhibit 28, which is a summary of Respondent Exhibit 29 and 30, which are invoices for legal services.
Okay, are there any objections to 29 and 30?
No, Your Honor.
Okay, Respondents exhibit 28, 29, and 30 are admitted.
In my opinion, the work identified in Respondents Exhibit 28 were necessary and reasonable fees that were charged to Tyrone Turner to enforce this court's order and protect the safety and welfare of the child, the subject of this suit, which has involved drafting pleadings, costs of court, responding to discovery, mediation, preparing for trial, and several court appearances regarding mother's motion for enforcement against the father, father's motion for enforcement against the mother, mother's motions to modify parent-child relationships.
Attorney Glickman, that was the expiration of your time. Okay, Attorney Thompson.
I just want to call myself regarding attorney. I apologize, Your Honor.
Well, you had a question to ask him on cross-examination.
Yes. Okay.
Go ahead.
Mr. Glickman, are you aware that there is already an amount that the court set forth in the initial enforcement?
Correct, and that is not included.
Okay, so why are we considering amounts that were not included already?
There was an order for attorney fees that was awarded on January, I believe it was 18th of 2023, pursuant to father's enforcement of visitation. And the attorney fees that are included in my summary are attorney fees that accrued since then regarding the pending issues in the pending suits, not the previous suit. We're asking for attorney fees that incurred in this suit that are open, that we're addressing today, and we're seeking a judgment and enforcement of the previous order for attorney fees in addition to the summary.
Okay, so you're asking for attorney fees for yourself and for another attorney?
Not for another attorney, for Tyrone Turner, and I reviewed his invoices and I determined that they're reasonable and necessary, and I incorporate those into my business.
Okay, and are you aware that some of these charges were for mediation that didn't have, we went to mediation on a modification. Are you aware that some of these charges have nothing to do with the enforcement?
I believe my testimony reflected that these attorney fees were accrued for the enforcements of both people and the petitions to modify of both people, which did include mediation, which mediation was initially supposed to help resolve the enforcement issues.
Objection, not responsive.
Sustained.
Okay, so Mr. Glickman, you can't really tell the court for Warren and Maglicio, you can't really tell the court what attorney's fees were for what. Is that an accurate statement? You just have a bill.
That's incorrect.
Okay. I'll pass it, Ms. Reiner.
Okay, and just so both of you are clear, there is already a judgment in place for the other attorneys.
Yes, Your Honor.
Right, they're asking for more attorney's fees based on the okay.
Right, there's already a judgment, so we're not doing an additional judgment there. Attorney Glickman, for your firm, that 21, you're saying it took you 21 hours to prepare for both of these motions or enforcements?
Yes, and I was put on this case less than 30 days before trial, so it took me a lot of time trying to get up to speed. It also included reviewing all of the case basically for the last year. There was an MSA, I had to review that. There were petitions, amended petitions, special exceptions filed by the previous counsel, my special exceptions that I thought we were going to pursue today, you know, drafting my requested relief, drafting cross and directs of both clients, proposed orders, corresponding with opposing counsel, attempting to reach an agreement on these issues.
Okay. That's all. Attorney Thompson, how much I don't know how to handle it's, hold on, let me mute you, Attorney Glickman. It's coming. Okay, I think it's gone. Attorney Thompson, how much did your client spend in service fees and filing this motion for enforcement?
Service and filing, it was $250. And I would also, if the court allows, like to file myself for attorney's fees as well.
Okay, go ahead.
Objection, Your Honor. She failed to provide expert disclosures or list herself as an expert to testify to the reasonableness and necessity of attorney fees.
Your Honor, that's not true. In the initial disclosures that were sent over, the deficiencies that were cured, I listed myself.
Objection, Your Honor.
In the court's witness list, I also listed myself and what was filed with the court.
She did not. If you look at what she provided in her initial disclosures, and I can pull them up right now, she did not make any expert disclosures under 195.2. And pursuant to the pretrial order, they are required to comply with those requirements of text rules of procedure. She failed to do so. And even she produced her initial disclosures on the 8th after I sent a deficiency letter. She still failed to list herself as an expert witness.
Your Honor, I listed myself, and furthermore, my witness list that was filed with the court, I'm listed on the witness list.
Okay, where are the disclosures? Because I don't see them on file with the court.
They were sent via email. I can pull them up.
I can share my screen.
Go ahead.
She failed to produce any invoices, any billing, failed to list herself as an expert witness. She's been on this case for over a year.
Counsel, I don't need the testimony. I just need to see the document.
There are no.
Counsel, it doesn't look like you designated yourself as an expert.
On number 4, I stated myself, Your Honor.
Let me see.
That does not comply.
Okay, did you submit any billing statements or anything that you would be basing?
I hadn't submitted them because I haven't added today, Your Honor, so I did not submit the billing.
Okay, did you submit them at the time of these disclosures?
I did not, Your Honor.
Okay, so the objection is the same. Counsel, you can stop sharing your motion.
And Your Honor, I would also like to object to the reasonableness of the attorney's fees presented by Mr. Glickman. Mr. Glickman was the initial attorney on the case. So even if he was just retained the second time,
hold on.
Even if he was just retained again a month ago, it shouldn't have taken Mr. Glickman 21 hours in 1 month when he was familiar with most of the history of the case.
Well, objection. This she could have cross-examined me. She failed to. That's an improper objection.
Okay, so this is what the court is going to do. Mother's motion for enforcement is denied. It is defective. The violations are not specific for contempt pursuant to 157.002 sections B 1 and 2 of the Texas Family Code. It specifically says that a motion must include the amount paid provided in the order, the amount owed, as well as the amount of arrearages. And if contempt is requested, it must also include the portion of the order allegedly violated, and for each date of alleged contempt, the amount due and the amount paid. The court is going to grant expenses and costs back related to Ms. Jackson filing the motion for enforcement in the amount of $250. The court is also going to grant the state's request for a judgment in the amount of $54,677.93 against the respondent, Mr. Turner, in this case. That amount is as of today, March 18, 2024. Mr. Turner is ordered to reimburse that amount at $323 per month beginning on April 1st, 2024. Mr. Turner, that's in addition to what you already are supposed to pay for child support monthly. Father's motions for attorney's fees. The court, there's no affidavit attached from the previous attorney, and the attorney is not here to testify to the reasonable and necessary fees that were billed, as well as there is not sufficient evidence to show that all those charges were incurred specifically for the motion for enforcement. And the request for attorney's fees by Mr. Glickman in the amount of $1,115, that is denied because the court does not find those fees to be reasonable and necessary for a motion to enforce. So councils, you all can submit an order, each one of your order based on my ruling today, and that is the ruling of the court, and you all are dismissed. Thank you.
Thank you,
Your Honor, could you reread me the section of the family code of what was missed? Because I thought we had everything.
Well, I'll give it back to you. I'll give it to you to go and read it. It's section.
Yeah, no, that's what I'm asking, just a section.
Yes, 157.002, contents of a motion. Specifically, B is about the motion for enforcement for child support. Is B 1 and 2. And it's also 3 is there too, but it says you may include a payment record. That wasn't what I was really focused on. It was mostly 1 and 2.
Okay.
Okay, thank you.
Did we get a ruling on the enforcement of fathers against mom?
Yeah, I denied it, and I denied the request for attorney's fees.
Okay.
Thank you.
Thank you. Have a great day.
Thank you, you all too.